Producing more detailed evidence.
The Minister was asked if he thought extending the 28-day limit was too tough.
I don't accept what we're doing is draconian to begin with. It is a, I think, proportionate response to a very, very serious threat. And I think, given, as I say, repeat, the sort of quantum increase in the sophistication, complexity and all the other elements that I spoke of in terms of plots that we've disrupted and plots that are ongoing, I think it would be remiss and irresponsible of the government to at least not look at this area. I think at the same time, keep that broad qualitative as well as quantitative review that you speak about. I think we need that from anything post 14 days, frankly, and we will. Keep and look very, very carefully at anything post 28 days in terms of judicial oversight, and as I say, the sort of portico or criteria to go beyond 28 days in the first place. But I do think, given all that we know thus far, it is important to go down those lines. It's a bit like saying, which again I hope is the case, as I said earlier, given what we're doing on acts preparatory, given what we're doing on potentially post-charge questioning, and may or may not do on interceptors evidence and some of the other elements in the proposed bill, they all mean that all of a sudden the whole landscape changes and we can do things in a completely different way. I doubt it. I think there will still be both, if I may, a little twilight zone around control orders and equally around something post 28 days. But I'm not afforded the luxury to wait and see if acts preparatory, post-charge question and a range of other things work before we make this provision, which on all our best judgment we think, given where we are, is important, but absolutely in extreme cases.
The Minister said there could be cases where more than 28 days detention is necessary.
We can't simply say, given the nature and sensitivity of all the things that we're doing in this area, we can't simply say, phew, everything's been fine so far, 28 days we think will pretty much cover everything, so we cannot possibly go beyond that, given what we do know about the quantum in terms of sophistication, complexity and the global dimension of some of these plots.
He was also asked about DNA and the process of DNA testing on suspects in the future.
I think there does need to be a debate that says that, is it useful for anyone who's ever encounters in whatever capacity the criminal justice system to, for perhaps a given period, have their DNA retained and then subsequently destroyed, or is that absolutely verboten and we shouldn't do it, and only those who have been charged with something should be on the database? I think, I don't know, I don't have all the answers to that. I just think there could be a very useful debate around that. Should we possibly have one with international colleagues from, in terms of terrorists, from legally sourced international databases? Well, we think in terms of this bill that would be very, very useful, not least given the international global dimensions to this struggle and this threat.
The issue of how proposed state measures could impact on individual human rights is a complex one. There will no doubt be further meetings like this one in the future.